So the first statement, special agriculture zone is to boost agriculture exports on same lines of special economic zones being promoted by government. And second one, Kaveri Delta area was recently declared as protected special agriculture zone. And third one, only agro-based industries would be given permission to be built in this. If you would have read the or been aware with the current happenings, you all know that Tamil Nadu CM has declared Kaveri Delta area as the protected special agriculture zone. So the first statement is wrong here, because it is not about boosting agriculture exports, or like it is not just like a special economic zone, because SEZ is basically to boost exports, and that too you'll have duty-free enclave. So there the laws will be different from whatever they have in the mainland. So but this is not in such type. It is basically to protect that area, or to use that land only for agriculture, not for any other activities. So that is the intention. So first statement is wrong here. Second one is correct, and third one is also correct, because the agro-based industries are somewhere related to agriculture, and that will help in promoting the agriculture. So that's why 2 and 3 are correct here. So the right answer is B. So now we'll see this in detail. So as I said, Tamil Nadu declared this as a protected special agriculture zone, and because of this or designation, usually what happened, the background story is that the central government has given some relaxation in environmental impact assessment studies. So according to that, if you give that relaxation, then the central government institutes or the public sector organizations can conduct hydrocarbon surveys there, and they can use for oil and gas exploration, like how people have done in the Krishna Godavari basin. If you know, Krishna Godavari basin right now is famous for this oil and natural gas. So similarly, they were able to do it in Kaveri Delta area. But so to avoid that, state government can delineate that area as special agriculture zone. So once if it is done that, then any institute has to take the permission from state government. So that way, state government took the control and gave certain protection to the farmers of that area. So that is the importance. And yeah, you can see the definition here, like it is one where agricultural land is preserved for posterity because of its importance to increasing agriculture protection and promoting livelihood security for a large number of farm families. So here it means like for agriculture it is to be continued for posterity, so that is for future also. And next thing, this is a concept not new. It has been proposed by Swaminathan much before, like in the 1960s itself, and he had proposed in various areas like Indira Gandhi Canal area in Rajasthan, where there was an artificial canal that was built, and similarly in wetland areas of Kerala and Punjab Haryana belt. So you can even write this kind of thing in whenever they ask something about Swaminathan recommendations in agriculture. And then you have, these are the areas, these are the districts that are covered. I'll just show you the map, it will be much more easy. So this is the Kaveri Delta. So Kaveri, you all know, it starts from Karnataka and then flows into Tamil Nadu. And last time, as I said, there was a question on Tiruchirappalli. So this is the city, and then Kaveri River goes through this, and Grand Anicut is also very important on Kaveri River. And these are the districts covered. This yellow area is the entire Kaveri Delta area that was declared as this agriculture zone. So you have Tanjavur, Tiruvavur, and then all the areas in this entire area between Kaveri and Bay of Bengal. So those are the areas covered, and it is bounded by Bay of Bengal on the east and Park Strait on the south. So till the south you have Park Strait, that is until Kerala border. And then reasons for declaring it is basically the Kaveri Delta region is anciently, like from the age of history, we know that it is mainly rice bowl, and it is rice bowl right now also for Tamil Nadu. So then many farmers are continuously dependent on that. That's why, that is one of the reason. And second thing, to avoid the hydrocarbon exploration. So that is about this special agriculture region. Now the second one, consider the following statement with respect to disaster management in general. Okay, so first one, the International Search and Rescue Advisory Group, INSARAC, is a network of disaster prone and disaster responding countries and organizations dedicated to urban search and rescue and operation field coordination. And second one, Global Assessment Report on Disaster Risk Reduction is released by United Nations Office for Disaster Risk Reduction. Third one, the Sendai Framework for Disaster Risk Reduction 2015 to 2030 is the successor instrument to the Hyogo Framework, but it is a non-binding agreement. So these are like statements directly verbatim lifted from their definitions. So that is why it might sound lengthy and bit technical, but read once again and then mark your answer. So 2 and 3, I guess most of you would have been aware of that, but the first one is something you might be reading for the first time. But that is also an important organization because that was frequently in news. Especially the context behind this is there was an BIMSTEC disaster management exercise that was done in India. So they done these exercise based on certain guidelines issued by this INSARAC. So that's why INSARAC is also very important. So here the answer is 1, 2, and 3. All the three statements are correct. Okay. So I've kept it deliberately correct so that you will remember these points, these statements, because these are the important points. So first thing, INSARAC. And then the third one, Sendai Framework is not a non-binding agreement. It is a voluntary agreement. So every country will do the national legislations and abide by the commitments voluntarily. There is no force. That is the first thing. And before 2015-30, there was an agreement called Hyogo Framework. That is also you have to remember. And then came Sendai. So right now we are in Sendai Framework. And this also, United Nations Office for Disaster Risk Reduction is an important organization at the global level that tries to enforce or enable this Sendai framework. Okay. Now we'll see these things in detail. So as I said, this was in context in news because of the BIMSTEC exercise. And we'll try to see about INSARAC. So INSARAC is basically this network of all the countries and the organizations that deal basically with this search and rescue. So here in INSARAC also, SAR stands for search and rescue. Okay. So wherever there is search and rescue and for the field cooperation, this organization comes into picture. So what it does, its functions are basically field coordination, emergency preparedness and response activities, efficiency, and providing certain standards and guidelines. Whenever there are teams that are going to deploy in the field, they will provide certain SOPs like standard operating procedures. So based on that, these regional organizations will conduct exercises and improve their efficiency. So and it is part of like UN Secretariat and it is based out of Geneva. Okay, these are the important facts about this. And next thing, this INSARAC also what it does is it does evaluation of the international search and rescue teams. Like it does evaluation and classifies them as medium teams, heavy teams, or low teams, like based on their preparedness. So that is something also it does. That is one of the function. Then we'll see different frameworks. So like I said, in disaster management at global level, we have UN Office for Disaster Risk Reduction, that is UNISDR, and the global platform for disaster risk reduction is an important event that happens for every 2 years. Okay, so this happens under this UNIDSR, and whenever it happens, it releases a report, that is global assessment report on disaster risk reduction. This is very important. Global assessment report on disaster risk reduction is released by this organization UNISDR. And then you have Hyogo Framework, that is basically from 10 years, from 2005 to 15, whereas Sendai is for 15 years, not 10 years. That is from 2015 to 30 and is non-binding. So right now, after 2015, we have 3 agreements that are basically promoting disaster management, that are Sendai, SDGs, Sustainable Development Targets, and Paris Commitment. You might be wondering how they have a disaster angle. Now, because climate change and disaster both are closely linked, there are certain common targets. You also need to know what are the SDG targets that talk about even disaster. Because if you see this concept like build back better of Sendai framework, that has very much in common with SDG. There is an SDG where you will have resilient infrastructure. So there again, it coordinates with the disaster management. Similarly, we have cities, sustainable cities. So there also the disaster aspect comes. So in this way, there are many SDG targets that coincide with Sendai framework. And similarly, the climate change also. So this is very, very important. The link between these 3 frameworks is very important, not just from films, but even from mains point of view also. Because they might ask a question asking you to link how climate change and disaster are linked. Then you have to know which is the SDG number, target number, how it is related to climate change, and then overall to disaster preparedness and mitigation. So this is Sendai framework. So like they have 7 targets. So these are the targets, like 4 are for decreasing, 3 are for increasing. In that 4, about decreasing mortality by 2030, and then number of affected people, economic loss, and infrastructure damage. And with respect to increasing, about national local strategies, disaster risk reduction, and then international cooperation and information sharing. And you have four priorities: understanding the disaster, strengthening disaster risk governance, investing in disaster risk reduction and resilience, and finally enhancing disaster preparedness. So these are the one outcome, one goal, four priorities, and seven targets. This also you have to remember, because Hyogo targets are different, Sendai targets are different. Sendai has four priorities and seven targets. If you remember this also, it is very much useful in writing even the answers. So now the third one. Consider the following statements with respect to Supreme Court judgments on criminalization of politics. So this again was in news because you have all known that criminalization has increased at rapid pace, like outpacing even economic growth. So if you see the first statement, MPs, MLAs convicted of crime and awarded minimum of 2 years of imprisonment loses membership of the House. Okay. Second one, convicted lawmakers will not lose membership if they appeal. It is not off. If they appeal against disqualification conviction in the higher courts. Okay. Second one. Third one, it is a mandatory for political parties at the central and the state election level to upload on their website regarding individuals with pending criminal cases and the reasons for their selection. So these are all the three statements based on previous Supreme Court, landmark Supreme Court judgments. Okay. So kindly mark your answer and then we'll see the right answer. So here, the first statement is about Lily Thomas judgment. So it is absolutely true. So first one, if any MLA gets convicted for more than 2 years, then he loses the membership. Second one is wrong here. Second one, in a famous case, in the Lily Thomas case itself, they said section 8(4) of representative of people act. So in that act, there is section 8 of 4. So Supreme Court said it is unconstitutional and it is strike down that act. According to that act, earlier it was possible. So like if you are convicted and if an MLA goes for an appeal in the higher courts, then she or he can still continue as MLA or MP. But now because of that judgment, the second statement is invalid. So second statement is wrong. Whereas the third statement is the latest judgment in 2020. So where Supreme Court said you not only need to upload the candidates of criminal antecedents, but you even have to establish the reasons why you are giving or why you are selecting that criminal candidates. So that's why 1 and 3 is the answer here. So that is B. Now we'll see in detail. So this is the statistics like from 2004 to 2019. So you can see like almost twofold jump, 24% to 43%. And Supreme Court, this is the latest context. Like Supreme Court said, you have to publish them and you have to give the reason. So we'll see the recent judgments. Lily Thomas we have already discussed. That is one striking down of section 8 of 4. And another thing is MPs and MLAs who are convicted more than 2 years. And then you have Association for Democratic Reforms case, ADR case. In this, it said like EC can obtain and disclose the background information of candidates. This is one step before the 2000 latest case. So at that time, it is EC who can obtain the information by the affidavit and can disclose the information on EC website. And then you have Kuldeep Nair case. In this case, it said Election Commission has complete control under Article 324. So you have to know this 324. This is also very important because if you remember, we have discussed about model code of conduct. And when someone violates that, as such, there is no legal backing to enforce model code of conduct. But Election Commission can use this article. That Article 324 talks, Election Commission can do anything to ensure the elections are free and fair. So according to that, it can use and convict or make sure that people are obeying that model code of conduct. So that is why Article 324 is important and Supreme Court already strengthened it. And then finally in 2020, this is the latest judgment where it said political parties have to give the information. Okay. Second thing, it has to give the reason. And third thing, in that reason also, it cannot say that just winnability as the reason. Like it cannot say, the political party cannot say because that candidate has winnability criteria, you cannot place that reason. So you have to give good reason why you are choosing certain candidate. And another thing, this has to be published in the national newspapers. as well as party social media handles. This is the latest one. So not only just in their website, but you have to give more attention to that, so that the basic intention behind this is people will be more aware of these candidates, and they will have an option not to vote for them. And in association with this, there is nota judgment also, where if people have only options of criminal candidates, then still they can go for none of the above. So this way Supreme Court has enabled or trying to decrease the effect of criminalization of politics. And apart from that, information has to be compulsorily published within 48 hours of selection of candidates, or less than 2 weeks before the date of filing of nominations. And the election commission has to be told about this complaints report, whether they are published in news reports, newspapers or not, whether they are posted in social media or not. All these things they have to get a report and give it to election commission. If not, then they will be booked under contempt of court proceedings. So this is about the latest judgment. So now the fourth one. Consider the following statements with respect to endangered languages. So first one, according to UNESCO, any language spoken by less than 1 lakh persons is considered potentially endangered. And second one, India tops the list of endangered languages, followed by US and Brazil in UNESCO Atlas of World Languages. Third one, the Central Institute of Indian Languages, Mysore, works on protection, preservation, and documentation of all mother tongue or languages of India spoken by less than 10,000 people in the country. Which of the following? Kindly mark your answer, and then we'll see the analyze each of the statements. Okay, so I hope you have done it. So here, if you can see, like there are two confusing statements here. Like in the first statement, I'm saying the people who spoke less than 1 lakh, and in the third statement, I'm saying 10,000. So you can understand here or can guess, like if there are people like of 1 lakh, then usually you can't consider them as endangered. You might give some other status like vulnerable or something. So that's why the first statement is wrong here. And if you eliminate the first one, then obviously you know the option here, that is 2 and 3. So it is correct. India is the #1 country in the endangered languages list. And then the Central Institute of Indian Languages is the main institute which was created in around 2014, I believe, to document the endangered language so that you can preserve their history. Because you all know that India is very rich in this diversity of languages, and it's very important for us to protect them. So answer is 2 and 3. So now we'll see this in detail. So the context for this is basically there was an Asur language, and Asur language is a language of tribal people of Jharkhand, and these tribal people are particularly vulnerable tribal group. So in vulnerable also there is particular category called particularly vulnerable. That means they are more vulnerable than normal tribal people. So you need to know these conditions also, like how the tribes are classified under particularly vulnerable tribes and what are the extra provisions they get. And there are certain tribes, in particular vulnerable tribes in Jharkhand, AP, Telangana, and all these areas. So kindly at least have a glance which are the groups under this. So that is first part. Second thing, what they did is they, despite having listed in this endangered list of UNESCO, they have started a concept called radio languages, like community radio. So through that they are engaging their community in this language. So that's why they're trying to conserve their language. That's how this became a huge news. Now we'll see what is this UNESCO Atlas of World Languages and all. So this list, according to this list, as we have already discussed, India is top that list, and then you have US and Brazil. And in India itself, Andaman Nicobar is in top with 11 critically endangered languages, and within the states it is Manipur. Okay. And the purpose of UNESCO Atlas of World Languages is basically to raise awareness about this language endangerment, and so that countries will start protecting those languages and to give them certain identity to these tribals. And next thing, the criteria. So how a language becomes an endangered. So according to UNESCO, like if the people who are speaking this language is less than 10,000 people, then you consider that language as endangered. That is the first thing. So now what government is doing? So government is basically has a program called, under this scheme, the Central Institute of Indian Languages is there, and that documents all the languages which are spoken by people of less than 10,000. And then you have these categories. like these are the language criteria and classification by UNESCO Atlas. So if it is like spoken by all generations, like there is transmission of this language from generations to other, like father to child and then further, then it is called safe. There is no problem and it is not included in this atlas. And then you have vulnerable, like only, like if you restrict the language to home and only children speak it, not much is used in the public domain, then it's called vulnerable. Like for example, right now we see Telugu status is also almost there in vulnerables. And then you have definitely endangered, where you have the children not speaking this language as their mother tongue, that is then definitely endangered. And then you have severely endangered. Here it is only spoken by grandparents and older generation, and the children or the younger generation is unable to understand or speak in this, then severely. And finally critically endangered, we have seen, like if it is less than 10,000 and that too not many speakers are there, even grandparents are also not much aware, then you have a critically endangered. And finally extinct, like if there are no speakers left for this language. So that is all this categories, so try to know these categories also, that is also important from this aspect. So now the fifth question. Consider the following statements with respect to women participation in armed forces of India. So the first one, the Supreme Court recently directed the central government to grant permanent commission to women officers in armed forces and right to command. And second one, Indian Army still has no women in combat role policy, where women are not allowed in combat roles such as army, infantry. And third one, in Navy and Air Force, women are allowed in combat role. So this is again a tricky question. Once again, read the statements carefully and mark your answers. So this first statement you might be all aware. This was a sensational decision and it was a progressive one. So that's why the first statement is correct. And then you have second one. Second one is absolutely true, and that is why they went to the court. So and still even now also there is no combat role even after the judgment, because judgment is talking not about combat thing, it is talking about giving the permanent commission and giving the right to command for women officers, not about combat role. So that's why second one is wrong. But in third one, you would have already read some news where Air Force pilots were trained, like women, first time women pilots came in Air Force and they were deployed. Even one of the women pilot was deployed in Balakot strikes also. So that's why Air Force is correct. In Navy, even before Air Force, women were inducted in combat roles like firing torpedoes and all. So that's why Navy and Air Force, this progressive move was done much earlier. So so all of the statements are correct here basically. Okay. So answer is 1, 2, and 3. Now we'll see the judgment in detail. So basically what happened is, right now with respect to Indian Army, like you have short service commission. So one, you will be recruited directly, and the other thing is short service commission. In this you will have only short service, and for women they can only serve up to 5 years. Okay, and that can be extendable to the maximum of 14 years. Beyond that they will not get permanent commission. That is why you call it as non-permanent commission. So they went to Supreme Court. And another thing, in 2019 government also came up with a new rule, like after 2019 whoever will be recruited by short service commission, they can be applied for permanent commission, but not for the people before short service commission in 2019. So these women, like it will be very injustice for them, because men have this option to go for permanent commission but not women. And next thing, they don't have retirement benefits. You work for 14 years in this commission and you come out of that, you might not get a private job. On top of that, you might not get pension services. So to do away with that, they went to Supreme Court. So Supreme Court said there is nothing doing, you have to give the permanent commission for them. And second thing, right to command. There were no officers in Indian Army where they can command the troops, because there was a feeling in army that people who are recruited from rural background cannot accept women officer as a commanding officer. So that also Supreme Court said we cannot rely on that justification, we have to go progressive in this area, and said you have to give women as a officer to command as well. But it didn't talk about combat roles. Even now in army, women are not directly given positions in combat services. So this is about Indian Army. And then you have Navy and Air Force, we have discussed this already. Okay, these are just the status right now, what it is there, you have to know, so that you never know what question can come in UPSC. And then you have sixth one. Consider the following statements with respect to Law Commission of India. So the first one, it is not a constitutional body, but is a statutory body. Okay. Second one, it came into existence in independent India after enactment of Constitution of India. Third one, Law Commission consists of 7 members with a tenure of 3 years. And fourth one, its recommendations are not binding on the government of India. So this is again more factual, and there are 4 options as well. So here your history knowledge should actually help you, because if you see the second statement, I'm saying it came into existence after independent India. But if you see the modern history part, you would have heard about Macaulay Commission, and that is nothing but a law commission. And there were many such commissions even before independent India. So that means second statement is wrong. So it started much before in British India period itself. And the first statement is also wrong, because you might not have encountered anywhere in Lakshmikant talking about an article talking of law commission, like finance commission, other thing. So that's why it is not constitutional body. At the same time, it is not even a statutory body also, because there is no statutory law saying about law commission. It is an executive body. So it is the government of India that appoints law commission to basically advise and support the law ministry. So that's why first statement is also wrong. And third one, it is correct. It is basically of 7 members and the tenure is for 3 years. And fourth one, obviously, if it is not a constitutional body, not a statutory body, then why government will listen? Like for finance commission and different things only, government will not listen. So why of law commission? So that's why 3 and 4 are correct here. So the answer is D. Yeah. So the context for this is recently in February, around in 22nd or something, the Union Cabinet has approved for constitution of the new commission, that is 22nd. So after independent India, this is the 22nd new commission that is going to be constituted. And usually the tenure will be for 3 years. And it will have 7 members. And next thing, you all know, it is an executive body, not a statutory, not a constitutional thing. And states also have certain permissions to enable their own law commissions. Okay, this is a provision. Not only center, but states also have this power. And first thing and next thing, in independent India, the first law commission was established in 1955. Okay, and since then, so far 21 commissions were there. And with respect to British India, in the entire history, the first ones was started in 1834, and the main provision is Charter Act of 1833. This also you have to remember, because they might ask, Law Commission of India is originated from which British India Act? So it is Charter Act of 1833, because this is the first act after which Macaulay Commission was came in, and it recommended for CRPC and IPC. So these are the 2 provisions that came out of that commission. And then similarly, various laws right now with respect to civil and criminal acts, what we have right now in independent India, were products of recommendations of law commissions, like the Indian Evidence Act, Indian Code of Civil Procedure, all these things. And next thing, it works as an advisory board for Ministry of Law and Justice. And then you have like the other functions, like it has to either undertake research activities on laws based on central government recommendation, or it can do on sumo motu also. Like if there are any burning issues, then it can take on its own and recommend to the Ministry of Law and Justice. And final thing is, no recommendation is binding on government. These are the members. Like you have chairman, 1 permanent member, 1 member secretary, 2 part-time members, and 2 ex officio members. So these ex officio members usually would be Ministry of Law and Justice secretaries. And then you have other functions, like you can go and revisit the existing provisions and then work to improve them. And important recommendations is another important area. Like what are the important things they have recommended so far? So if you see, you don't need to remember the number of report, but remember that it has recommended. Law Commission has recommended abolition of death penalty except in terrorism related offenses and war against the state. So that is first thing. Second recommendation is about simultaneous elections. So this is again very, very important. There might be a question also asking whether Law Commission has recommended this. Yes, Law Commission has recommended in 1999 and also in recently in 2018 or 19 also, that it again reaffirmed simultaneous elections can be held, and it also suggested some way forwards for certain challenges also. So that is also important. And this is even more important when you are writing a mains answer. Like you can straight away, when a simultaneous question comes, you can write there, as law commission recommends, these way forwards can be used. So that way also it would be useful. And then you have criminal law amendment bill in 2017, where we have inserted some sections. So that was also recommended by law commission. And finally, law commission also favors uniform civil code. This is also so much in news because of triple talaq. After triple talaq, the next move of government is uniform civil code. So that's why this is also important. So these are the major recommendations so far from law commission. So now we'll see the 7th question. Consider the following statement with respect to Foreign Contribution Regulation Act, that is FCRA. This is again very, very important. So first one, foreign funding of voluntary organizations in India is regulated under FCRA Act and is implemented by Ministry of Home Affairs. Second one, under the Act, organizations required to register themselves every 5 years. That is, they will get the license and that license is valid for 5 years. An NGO must be in existence for at least 3 years for registration. This is another condition. So this is again completely fact-based, like you need to know the provisions, because this was again in news. There was constant conflict between NGOs and the government. So that is why this was in news. So if you see the right answer here, all the 3 statements are correct. Okay. So 1, 2 and 3 are correct. So answer is D. So now we'll see the context and in detail, like how FCRA was evolving. So if you see recently in 2020 February, the union government has for the first time after many years has granted license for 20 NGOs, including there was an NGO by AR-Rahman. So that was so much famous. And why these NGOs are mainly controlled by this FCRA Act is there was a report by Intelligence Bureau saying in 2015 that there were many NGOs that are getting foreign contributions and are using that funds for anti-India activities. Like for example, when there was a Russian plant, this Kudankulam nuclear plant, there was huge protest there. And it was found that there were many NGOs, foreign NGOs, funded by US to protest against Russian power plant construction, because they don't want other country to do power plant construction, as there was no US plant here. So that was a kind of geopolitics playing out. So not only that, even in anti-terrorism, terrorism activities and other things, they have certain suspicions. So that's why NGOs foreign contributions are tightly regulated by Ministry of Home Affairs. So for this, they have enacted this FCRA Act. And initial one in 1976, they have prohibited or they have controlled the fundings for both political organizations and other organizations. Okay. And then there was an act in 2010. So that repealed the 76 and it came up with the new provisions. These provisions are important for us from Prelims point of view. So here, there was a provision to cancel the license for NGO. They can close an NGO by Ministry of Home Affairs if they find that their contributions are being used for political or neutral, or if suppose they are using it for anti-India interests. Okay, that is first thing. And second thing, the license is for 5 years. If they get the license for an NGO to get the funds, that is for 5 years. For every 5 years, they have to apply again. And second thing, to apply for that 5 years license, that NGO needs to be in India for 3 years. That should be working for 3 years. Then only you can apply. And third thing, like if there is any person who is inserting the assets, and that should be disposed in the manner suggested by the government. And if they are getting the funds, that should be in a separate bank account, and that bank account details should be given to Home Ministry. And apart from that, that NGO should have to file an audit report every year, annual expenses report to the Ministry of Home Affairs. So if you remember, like there were a couple of incidents where Greenpeace, Amnesty International were freezed because of these not filing of audit reports. So that is another important provision of FCRA Act. And then you have, before discussing NGOs thing, then we have Finance Act 2016. So till 2016, the political parties were also not allowed to get funds from outside. But in 2016, they have made an amendment where they said they changed the definition of foreign entity. They said when a firm, if it is having less than 50% of capital owned by a foreign entity, then you cannot consider it as foreign one. You can instead consider it as other thing and can accept the donations for even political parties. So that is first thing. And they said like from 2007, like any party, if it is getting fund, it falls under this. If it is before that, then earlier law will apply. Okay. And then in 2018, even that was also diluted. Now it said any party, if it is getting fund from right from 1976, then that will, this law will apply. That Finance Act 2016 will apply to that party from 1976. That means any party can, or if you would have already got fund, then they would not be subjected to any proceedings. So this way they diluted completely the FCRA Act. And then finally, in the latest move, you would have seen in electoral bond scheme, they have even diluted further by allowing foreign companies to even donate to political parties in much more liberal way. So this way, right now, FCRA is mainly to regulate NGOs. And this NGOs thing we already have seen. Like everything, they have to find the annual report and all. So those are the FCRA regulations and NGOs conflict. So now we'll see the final topic, that is the eighth one. So consider the following statement with respect to promptive corrective action framework of RBI. This was also very much in use because this has, RBI has imposed very strict conditions on certain banks. So the first one, RBI monitors the financial health of the banks in terms of 4 indicators. First one is CRAR, that is cash, no, it is risk assessed ratio. Okay, it is cash risk assessed ratio, I believe. We will see that in the further in the slides. So that is CRAR, and then you have net NPA, and then you have return on assets and Tier 1 leverage ratio. And second statement is, under PCA, RBI can impose certain restrictions like halting branch expansion, stopping dividend payment, and even can supersede the bank's board. So these are the impact if a bank falls under PCA. So once again, read them and mark. So I guess it is very easy because these are the basic things and both the statements are correct here. So option is 1 and 2. Now we'll see them in detail. Okay, it is capital to risk weighted assets ratio. So yes, so RBI, basically you all know, like after 2014 there were huge twin balance sheet problem in banks. So to address that, RBI has brought one of the provision is prompt corrective action. So in this, what they do is they'll assess the financial health of the bank by taking certain parameters. And if that parameters fall under, then that bank will be categorized as a risk bank. And then they will enforce certain restrictions, like based on how much threshold it has crossed. So if you see the components on which, or criteria on which it does, first is capital to risk weighted assets ratio. So this is basically the bank's capital, like the money, how much bank can keep aside to withstand this risks, like whatever the risks it might have. Like for example, if it has gross NPA of more than 12%, then how much it can keep aside capital to address those risks. So that is capital to risk weighted assets ratio. So under Basel III norms, RBI has imposed the CRAR as 9%. Okay. So if any bank is not getting up to that rank, then it will cross that criteria. Second thing, net non-performing assets. So here another important thing is net. So net means you will basically take the gross one. Gross is like total non-performing assets. And then if you subtract provisioning amount, then it becomes net non-performing asset. Provisioning is like same thing. If you know that an account is there and you will not get the money back, then you will consider it as non-performing asset. And if you keep certain profits of bank aside to cover that losses, then you call it as provisioning amount. That's why in Hindu, if you read, you'll daily encounter this provisioning amount has been set aside and all out of the profits. So that they do it for reducing their net NPA. So here also, if the net NPA is going to cross above 6%, then again this condition will be satisfied. Then you have return on assets. So this is basically profit that is gained by the bank on the total assets. So that too after deducting the tax. So if it is getting that, then it is called as return on assets. So they will see for 2 consecutive years, and for 2 consecutive years, if bank is in loss, that is it is not getting any profit, that is net negative return for 2 consecutive years, then again this condition is satisfied. And then you have finally tier 1 leverage ratio. So here again, the capital will be divided in tier 1, tier 2. So tier 1 is a kind of good capital, like is more asset kind of capital. So if that capital ratio, leverage ratio is less than 4, even then that condition will be satisfied according to RBI. So out of these 4, if any bank satisfies them, then you will go for uh, the impact of this. So once if any banks fall under this framework, then RBI has certain conditions where it can impose either ranging from these 4 options. It can impose all of them or some of them based on how much worse the condition is. So like it can stop bank from expanding its branches. It can even stop giving the dividend shares to shareholders, and then limiting the lending capacity. Like if you have seen in the recent past, there were many banks that came under this. Like right now that merging banks like PMC Bank, and even before that, like out of 20 public sector banks, there were about 12 banks that came under this corrective action because of stress of NPS. So now slowly, I believe last time the data I've checked, it was like 8 public sector banks were there in still PCA. And now because of coronavirus, we don't know how much will go again back to the status. So that is the thing. So this is how RBI is trying to control the failure of banks by having this kind of framework.